Okay, we're going to start. My name is Richie Eppink. I am a lawyer, and I am a member of the Idaho Trial Lawyers Association, which is putting on this training and putting on this clinic. The Idaho Trial Lawyers Association is an organization that believes that people should have access to the courts, that people should have access to justice, that we should have trials by jury, and that people should get their day in court. And beyond believing that, ITLA actually puts their time and their money and their resources into making sure that that actually happens. And some of you may be cocking your head a little bit and thinking that maybe all lawyers do that. I won't give away any spoilers today, but maybe one of these days you'll see a brief or you'll see a bill that somebody's lobbying for, and you'll realize that there are some lawyers that don't seem to work for that in real life. One of the ways that ITLA does this, works for access to justice, is through the Street Law Clinic, which hopefully is the reason why everybody's in the library before it opens right now. So that's what we're going to be talking about today. The Street Law Clinic is almost a year old. I think it started in February of 2013, and it was sort of the brainchild and the project of Erica Birch, who's another ITLA member. Unfortunately, she can't be here today to explain the clinic. The quality of at least this part of the program will be significantly reduced because of that. But essentially, the idea of the Street Law Clinic is to fill a really significant gap that exists here in the Treasure Valley, or it used to exist in the Treasure Valley and still exists in pretty much every other part of Idaho. And that gap is the fact that if you need a little bit of orientation or navigation with the legal system or with a legal problem, and you can't afford to hire an attorney for the 30 minutes or an hour that you're going to need to even determine whether or not there's something that the law can do for you. There used to be no place that you could go, more or less, in Boise or throughout this region to get that. None at all. And the Street Law Clinic now provides that. And fortunately, I guess, most of you will not know really firsthand just what it looked like before the Street Law Clinic began to fill that gap. But I can tell you that the Street Law Clinic has had a serious, significant impact on the ability of people to at least get their hands around what's happening to them legally. How it works is it happens now twice a month, on the second Monday of the month and on the fourth Monday of the month, here in this building, not in this room, but in this building downstairs. And on the second Monday of the month, it's everybody, and their cousin can come. On the fourth Monday of the month, it's focused on family law issues exclusively. And people can come. I actually don't know if there's I guess there is some sort of a means testing, an income test, or there's not. So there's not really even an income test. You can come, whoever you want can come, and signs up and then gets an opportunity. There's this really kind of Wizard of Oz-like setup where all the lawyers sit behind this curtain, and law students sit out at desks like this. And so you would sit out at these desks if you're a law student, and one of the clinic people who have come to the clinic will come to you and explain what in the world is going on with them that they decided they needed to come to a free clinic at the public library with lawyers that sit behind a curtain. And once you understand what they're telling you, you begin to ask questions that help you get the information in a short amount of time that you need to sit down and talk with a lawyer or two or three lawyers and troubleshoot this person's problem. And so later on today, we'll be talking about those practical skills after we spend a significant amount of time this morning looking at least getting brief orientations on the substantive areas of law that are most frequently encountered during the clinic. And so you hear what this person's problem is, you ask the right questions hopefully, and then you go behind that magic curtain and talk to an attorney or two about what is going on with this person. And hopefully there's some lawyer back there who knows not only about this area of law but knows what they're doing, and they will help you either craft some ideas, some advice. It might not be advice, it might be a referral, or in some cases it's an issue where the lawyer will come out from behind that curtain and talk to the person directly with you. You may be wondering what's the purpose of this curtain, and I don't know exactly what the purpose of the curtain is, but I can tell you from my own experience that when somebody's talking with a law student versus when someone's talking with a lawyer, they seem to be often a little bit more economical and efficient in the way that they explain things. Unfortunately, this is a symptom of what the bar basically is responsible for. Some portions of it accepted, like in my opinion ITLA, but we really have in some sense a whole lot of lawyers, but they're not distributed properly. And by the way, my opinions are my own and not ITLA's as far as I know. So to the extent that I start editorializing, you can blame it on me. But in any event, my opinion is, and I think that you'll see this borne out if you actually look at the way things work in Boise, is there's a whole bunch of lawyers and there's almost none who are providing the kind of help that we provide through the Street Law Clinic. And for that reason, when people who have no chance of ever being able to afford a lawyer to do anything for them get a chance to talk to a lawyer, they don't want to stop, and I don't blame them. So anyhow, that's a little bit editorializing about how that curtain works. And ultimately, the goal here is not necessarily to solve someone's problem that night, because frankly, most of these problems that we see at the Street Law Clinic, we're not going to be able to solve in a night, and frankly, they may take months, if not years, to solve. Now, it would be nice if ITLA or some other organization had enough lawyers and enough resources to be able to solve many of these problems, because you will hear cases that are heartbreaking, cases that are compelling, and cases, most importantly for what we're talking about, that are legally meritorious, significantly meritorious. However, there's not those resources in this valley, and frankly there's not those resources anywhere in the country that I know of. And so we are trying to, in a short amount of time, provide a little bit of advice in many cases that will help someone start taking their own path towards a just resolution of their issue. And that may mean helping them find forms so that they can litigate something themselves, helping them find forms so that they can write a will or a power of attorney or do something with their kids on their own. But we're not generally going to take anyone from point A all the way to the end of the line at the Street Law Clinic. Now, sometimes there will be a case that's not only compelling and not only meritorious, but also is clearly going to be over someone's head. And in some of those cases, probably not all of them, but in some of those cases, we are able to, if we have a willing volunteer law student and a willing volunteer attorney, able to offer to take someone from point A all the way to the end of the line, or as close to the end of the line as we can get that legal problem. Doesn't happen in every case, doesn't even happen in most cases, doesn't even happen in a whole bunch of cases. It happens in some of these cases, but it'll be your job to try to spot those, along with the lawyers who volunteer at the clinic, to try to spot those cases. And if someone's really going to be over their head and has a really compelling case, those are the cases where there might be some ongoing work outside of the clinic. I think that's the clinic in a nutshell. we're going to start on a whirlwind tour of these sort of issues that are typically going to come up. But before we do that, let's pause for a second and recognize that this thing is really cool, and maybe we'll get to play with it in a second. I don't know. But is there any questions about how the clinic works, or what the clinic is, or what ITLA is, or any of that stuff? All right. We're going to start with so late breaking news. Oh yeah, so there's some changes in the program, but we'll get to that. Don't worry about that. Also, there's some other stuff on here that probably is better to announce at the end of the day. Oh, there's all sorts of stuff in here. In any event, Taylor Mossman is here. That's great, because I think she's great. Taylor, come on up, and I'm going to give you a microphone, and you're going to tell folks about, if you want me to tell all this story about hiking and backpacking and stuff, I can. Do you want me to do that?
Okay, no.
Okay. Everybody read your program. Taylor was George W. Bush when I was Dick Cheney on the Student Bar Association at the University of Idaho a long time ago.
Those are not the two that I would pick.
I was Joe Biden when you were Barack Obama.
There we go.
And Taylor's going to talk to you about Social Security and public benefits, and I'm listed in that part of the program too, but Taylor knows more about everything than I do, so we'll see if I have to even stand up again.
Okay.
Go for it.
All right. Thanks, Richie. Well, first of all, I also love Richie. He's been a huge inspiration for me when it comes to public service, particularly in the legal field. He has really brought our legal profession up to...
You got 15 minutes, Taylor.
Just ease up. Hang on. I think, in my opinion, anyway, and again, these are not the opinions of the ITLA, he's really brought our legal profession up to another level when it comes to dedicating ourselves and trying to dedicate ourselves to public service and providing free legal services to those in need. Full disclosure, I have never actually participated in the Street Law Clinic, but as Shannon knows, we do something very similar through the IVLP. Mary Hobson has a homeless clinic that we try to do every month, and we usually go down to Corpus Christi now on Saturdays and just set up shop there, and then the homeless folks can come in and talk to us with any legal question that they have. And so it's very similar to the Street Law Clinic. I don't think that we are perhaps as thorough in our legal advice. It's usually just one or two questions that they come in and ask us. We try to give them a reference or a referral and some general advice, and then send them on their way. And then sometimes it can turn into a case, kind of depending on what the nature of the issue is. But so my name is Taylor Mossman. I work at Mossman Law Offices here in Boise with my father. We have a practice that is primarily dedicated to Social Security, disability, and workers' compensation. And so as far as public benefits go, I'm going to be primarily talking about Social Security benefits today. Raise your hand if you're familiar with the difference between SSI and SSDI benefits. Kinda? Okay, good. Because that's what I'm going to talk about quite a bit today. So the Social Security program, as you know, when you become disabled, you apply for Social Security benefits. And I'm sure you've heard a lot in the news about, you know, the financial status of that program and the retirement program in addition. And you know, so far I haven't seen them make any major cutbacks to the program so far, but I guess that's to be seen down the road. So I help folks obtain both types of benefits. The SSI, which is an acronym for Social Security Supplemental Income Benefits, is basically what we commonly refer to as the welfare program. The SSDI benefits, which stand for Social Security Disability Income, is what we commonly refer to as disability. When people say, oh, I'm on disability, that's what that means, is the SSDI. So, and there are two different ways that you are eligible for these programs. With SSI benefits, the Social Security Administration is going to look at your asset and income level. And by the way, for both programs, you have to be determined medically disabled to be eligible for benefits. So you have to be disabled under both programs, and I'll talk about what being disabled means in just a second. But for the SSI program, they're going to look at your asset and income level to determine whether or not you might be eligible for this program. So if you are applying for SSI, you have to be well below the poverty level. You can't have anything in excess of about $2,000 in assets. So you can't have a retirement account, you can't have a savings account, checking account with $2,000 or more in it. And they will exempt your car and your house, one car. They will not exempt two cars. And so if someone comes to you and they say, gosh, my bank account is just down to $4 and I don't have anything else to speak of. So you're going to want to ask them what kind of assets they have beyond that. Do they own any land? Do they have cars, a house, retirement, anything like that in their possession? And if so, if it's anything in excess of $2,000, then they're probably not going to be eligible for this SSI program. Now, the kind of the unique thing about SSI that I feel like a lot of people don't know about is that you can be eligible for this program without ever having worked a day in your life. A common case that I see is you see a female, typically age 40 to 50 something, who has raised her kids and hasn't worked since she was a waitress in college. And all of a sudden her husband meets some hot new chickadee and leaves her, and she's got the kids, but she has zero work history, zero training, and no money to speak of. And so she would be someone that would probably be eligible, again, if she is less than that $2,000 threshold for these SSI benefits. So the SSDI program, Social Security Disability Insurance, this is the program that I think works a lot like a car insurance premium. When all of us work, we pay into the FICA tax system, typically, unless we're self-employed and paying our own taxes, and sometimes we forget to do that. But if you're employed, generally your employer is going to pay these FICA taxes. And what those FICA taxes go into is the disability insurance program. And you earn quarters of coverage to be eligible for the disability program. A general rule of thumb is that if you work for 10 years, then you're going to be eligible for the disability program for another 5 years after you stop working. And then your insurance will expire. So very much like a car insurance premium. You pay your premiums, you get in an accident, you're going to be covered in the accident even though you stop paying your premiums, as long as you were covered at the time of the accident. Does that all make sense? Okay. So the benefits for both programs, the SSI program and the SSDI program, are very different. Under the SSI program, the maximum amount of benefits that a person can get per month is, in 2013, I think it's $710. And now I think it's gone up to maybe close to 715 or somewhere in there. But that's the most that anyone's ever going to get under SSI program. And by the way, children are also eligible for the SSI program if their household or parents don't have incomes and assets in excess of a certain threshold as well. So a lot of families don't know that. If they have a child that's disabled, then they can be eligible for that program and get those benefits. The benefits for the SSDI program are going to depend very much upon what the person has paid into the FICA tax system. I don't know, a lot of you might remember getting those green statements from Social Security. They stopped sending those out, but that would generally tell you what your primary insurance amount is or what you would receive per month if you did become disabled. And so that, if you're a strong wage earner, then you're probably going to earn close to $1,000 a month. I had a doctor once who became disabled, and obviously a doctor's going to be a very high wage earner, and his primary insurance amount was up to $2,600 a month. And so it really does depend on how much you're earning and paying into that FICA tax system. So, as I stated before, for both programs, you do have to be disabled. So what does it mean to be disabled? That is a very broad and big question, and we're not going to be able to get into all the details of that today. But these are very common conditions that I see walk through my door, and what you would see in the street law clinic is definitely going to vary. But I see a lot of mental health conditions and a lot of spinal arthritic conditions are probably the two biggest ones. From a mental health perspective, you're going to see bipolar disorder, schizophrenia, anxiety, depression, borderline personality disorder, those kinds of things. And the mental health side, and I would say that's probably something that I also see more of in the homeless clinic as well, are these mental health conditions. And the way that you prove you are disabled under the Social Security Administration guidelines is through medical evidence. And with the street law clinic and the homeless clinic, what you're going to find is that people probably don't have medical insurance. Maybe now you're going to see more who do with the Affordable Care Act, but they don't have very many resources for getting the medical care, particularly mental health care, that they need. And so what I find that I'm doing a lot in the homeless clinic is providing them resources with free or low-income clinics that we have in the Valley. And unfortunately, those resources really are pretty limited. One of the biggest resources that we do have is the Terry Riley Clinic. And there's I believe there's some, I know there's one in Nampa and Boise, and I think there's some in, I'm going to get this wrong, Middleton maybe, I can't remember, but somewhere west of here, there's a few more of those clinics. And they do their treatment on a sliding scale, and will help people who are low income get that medical care they need. Because if they are applying for disability benefits or for SSI benefits and they don't have any medical treatment to speak of, then they will get denied. It's just, it's just that simple. You can't just go in and apply for benefits without proof that you're disabled. You need some type of statement from a treating provider, or
Does the Terry Riley Clinic deal with mental health as well as physical health issues?
They do. They have a behavioral health side to their clinic, and that's great that they do. St. Alphonsus also has a low-income behavioral health component to their hospital, and that one I know less about. I think that you just have to go in and apply, really, and then they look at your assets and income and determine whether or not you might be eligible for their program. And I think that they have more limited availability than, I think Terry Riley, if you are at that level, at that, that threshold for income, then they'll accept you no matter what. But I think St. Alphonsus has stricter guidelines.
But if you're talking about assets under $2,000, aren't most of these people going to be covered under welfare or something along those lines, or Medicaid?
Surprisingly, no. And it's a big problem. It's a big catch-22, because what I find happen is that people, if you go down and apply for Medicaid, they'll say, okay, we'll give you Medicaid if you're disabled, but we're not going to give you Medicaid if you're disabled. And then you can't get on disability unless you have medical treatment. And so these people are just going around and around in circles. And my big hope with the Affordable Health Care Act is that some of that is going to resolve. But the Medicaid expansion in Idaho hasn't really gone anywhere. It doesn't look like it's going to go anywhere right now, and so that's problematic. There are certain people who do automatically qualify for Medicaid, and it's younger individuals, pregnant moms, younger moms, and then people who have very clear medical conditions, diagnoses. But with these mental health and other, physical related problems, they're not as clear cut, especially when you're dealing with something like pain, which is subjective. A lot of mental health things are all subjective too. And so no, I mean, you would think that would be the case, but it's really not, and it's very frustrating. So again, for your purposes, most of the advice that I find myself giving when it comes to these SSI and SSDI benefits is giving people resources for medical treatment so that they can establish that they are disabled before they even apply. But that being said, if you do have someone that comes in who has had some medical treatment under their belt and they're ready to apply for benefits, then I can give you the number to the Boise office for them to call. It's 321-2900. And they can also, just provide, that office is generally pretty helpful. It's a little bit frustrating to get through to them sometimes, and they have weird office hours, but they're generally pretty helpful with anything when it comes to applying for Social Security benefits. They'll answer almost any question. So what questions do you guys have for me? Yeah.
For the medical evidence, does it have to be a physician or can it be a nurse practitioner?
That's a good question. Under the Social Security guidelines, they have basically stated that an acceptable medical source is someone with an MD or DO behind their name. So they give more weight to the doctor or DO than a psychiatrist also falls on because they have an MD. But that being said, I've had plenty of cases where I've gone in front of the judge with just treatment records from a nurse practitioner or PA, and they will give that serious consideration. But if they are not finding the claimant to be credible, then it's sort of an easy out for them to say. Yeah, exactly. And I have my own views about that because in my experience, what I'm finding here is that nurse practitioners and PAs, they have the ability to prescribe medications, and they're the ones who are providing the majority of treatment anyway. And it's, you kind of have doctors behind the scenes looking over things, but it's the nurse practitioner and the PA who know the individual more than anyone. So that's kind of, I have my own frustrations with that rule, but that's the way it sits right now. What else? That was kind of a lot thrown at you all at once, but yeah.
And the 321-2900 is the Social Security office?
Yes, that's the Social Security office. And actually, if people want to apply for benefits, and they're able to, and maybe this is even something that you can help them with through the Street Law Clinic. We help people do this in our office, oftentimes on a pro bono basis, is we help them apply online. And that website is www.ssa.gov. And it's really pretty streamlined doing that. If you're at all computer literate, then you should be able to do that. But like I said, if that's not something that you're comfortable with doing here at the Street Law Clinic, you can refer them to us, and we can help them do that too. So, did I give you guys my email? Okay, it's Taylor, Taylor, at Mossman Law, MOSSMAN, mossmanlaw.us. And yeah.
What's your advice to say homeless folks who don't have an address, or like maybe they have an email address but they don't have reliable means to access it? I mean, what do you tell those folks as far as, we can submit an application, but you have to be available for follow-up questions or the rest of the procedure?
To be honest, I haven't really run into that problem. I think that even most homeless people I encounter have something set up at one of the shelters or a P.O. box somewhere. And if they don't, then I would encourage them to do so, because if they want to see any of these benefits or communicate with anyone, then they're going to have to do something, along those lines and take some initiative there. As for an email address, I'm fairly sure that, places like Corpus Christi and the library even give folks access to their accounts or access to the internet so they can access their accounts. So that would be, I guess, my thought.
When you say appear in front of the judge, which court are you talking about?
Okay, so this is usually when attorneys would actually get involved and fees are generated, is if people apply and they get denied, then you appeal the decision in front of an administrative law judge. And that's where I represent people, is in front of the administrative law judge. And those hearings are usually held at the old MK Center, which is off Park Boulevard, and it's just an administrative law judge hearing. And I can get into a lot of detail about that. If you ever want to call me and talk to me about it, then I'm happy to do that, but that's kind of a lot for today's session, I think. And again, generally at that point, that's when they would, there's plenty of attorneys in Boise who would take cases to hire, to be hired to do that, because it's all done on a contingency fee basis. And so I have several homeless, clients who don't have to ever pay me a cent. And then if we're successful in getting them benefits, then my fee is taken out of their back pay benefits. And for homeless people, usually we'll waive the fee anyway so that they can keep their back pay benefits. So.
What is your contingency fee on that?
It's actually regulated by the government.
25%?
Yeah, it's 25% of their back pay benefits, and then they cap it at $6,000. Any other questions? No? Okay.
Thanks, Taylor.
Yeah, thank you.
You can learn to do that on your own, but I'll help you this time.
Oh, I forgot to mention, I'm so sorry.
Go for it.
There is an intake form that I commonly use in my office for new Social Security clients. And it's just information that you want to take down and that will help you with your
Again, Taylor at Mossman Law.
Mossman. Exactly. That's pretty cool.
Yeah, no, it
Oh, I'm so sorry.
all that work.
I got too curious. Homebrew?
Just whip it up.
All right, anyhow, I'm writing this down just because I've been wanting to do this all day. And we're going to move on to, I know your thing says family law, but we're going to get to that later on because sometimes judges are more important than ITLA. And Shelley's talking to the judge.
It's mossmanlaw.us.
Guess what? All right, that's Taylor's address. So we're going to switch family law with immigration law. And Angela Levesque is here, immigration lawyer extraordinaire. Take this microphone and tell us all about immigration law. You have 5 extra minutes, so you get to go
That's
till
actually very helpful.
10 till.
Okay, great.
And then I'll worry about saving us the other time later on. So you don't
Thank
worry
you
about
so
that.
much. All right, so immigration law is a huge subject. I'm not going to be able to give you actually everything in 20 minutes, but I did provide some sort of very basic materials. They should be online at some point. You'll be able to access them. If you need any other further assistance, you can always contact me, or there's also other resources. We have a small little immigration group, and we all kind of know each other, and you can do it that way. There are immigration resources for people without funds. There's the PILN, there's the Pro Bono Immigration Network. And so we basically, in that group, we do removal defense for people who don't have the means to hire an attorney. There's also the Mexican Consulate for Mexican nationals. They might be able to pay for a case and the filing fees for a case. They usually focus on victims of crimes and people who can obtain permanent or lawful presence with being a victim of a crime, or deferred action for children who came as children. And I'll discuss those, I think, through the intake. So if you want to follow along, I'm just going to go through the intake and kind of tell you why I put things in there and discuss the benefits that way, or the way that people can apply for status or some sort of documentation there. So obviously, full name, date of birth, you guys understand what that means. A number is an alien number. On occasion, people will have an alien number, which is a number immigration assigns to you if you're in their system. Sometimes if they're in the system, they might not actually have a number because they have a temporary visa or some sort of temporary status. So don't worry if they don't have it. Citizenship, obviously, you guys understand what that means, but be aware that sometimes people are born in one country and have citizenship of another, so make sure to put that correctly. Current status, that means the person's actual current lawful status. They might tell you, I'm undocumented, or I'm illegal, as the colloquial word is, or they might say that I have a B visa, and they will give you maybe other types of alphabet soup visas. You'll be like, what is this? Don't worry about it, just put it down as best as you can. If the point is, if they're in lawful status, sometimes that's different from obviously if they don't have lawful status, and what benefits they might be able to obtain, or depends on the problem they have. Expiration of that status, this is something that's important to note. People often, I find, look at their visas, and the visa is that little page in the passport that immigration sticks on that allows you to come into the country. That's not necessarily the individual's actual lawful status. So if you're outside of the country, you need a visa to get in. Once you're at the border or in the airport, immigration is going to inspect you or review that visa and decide whether to allow the person in. If they allow the person in, then they're going to get a lawful status based on that visa. So they will have, for example, a B visa, which is a tourist visa. They'll come into the airport and then get the status of a tourist, or a B status. And the way you know is they'll stamp their passport with, the date that they entered and the date until when the visa or the status expires. So they also get a little white piece of paper, or actually no, they're not getting those papers as of this year, sorry. You have to go online, but whatever. Sometimes they'll have these white papers, sorry, the rules change all the time. But sometimes they'll have these white pieces of paper which also say until when their status expires. So people often confuse the status with the visa, and people will tell you, oh, my visa is good for 10 years. That doesn't really matter. It depends on how long the status is valid. So the status, like for example, for a B visa will often be just 6 months. So that's kind of good to know, and they might accidentally overstay. So always check that if you can. Next is the listing of the immediate family members. There are sometimes, there are different ways to obtain lawful status or some sort of status. One is through family, two is through employment, another is through victim-based immigration, and there are other kind of miscellaneous that we won't talk about. We're going to talk here about family-based immigration. There are only certain family members through which you can gain a permanent residence, which include your parents, your partner. Of course, you need to be married, so your partner, marriage, your children, your siblings, and not really directly your grandparents, but I do include the grandparents because you can obtain derivative citizenship through a grandparent in a chain of derivative citizenship. So grandparent may have been born here, may be able to pass on the citizenship to the parent, and the parent to the potential client. So I put that on there just in case. Obviously their full name, their relationship, their date of birth, where they are, and you put their immigration status to the best of your knowledge. Deferred action is the next area that I want to talk about. Now, deferred action, or DACA, is basically deferred action for childhood arrivals. It's something that was created in 2012, and it's basically a watered-down DREAM Act. Have any of you heard of the DREAM Act? Hands? Yeah? All right. So basically, it's some sort of permission for kids who came over, or adults or people who came over as kids without any sort of consent, or came over, maybe they're undocumented now, or came over directly as undocumented people, and they've basically grown up here, they have roots here, so it's kind of unfair to remove them or deport them. Well, we don't have really a great Congress right now, so they weren't able to pass the DREAM Act, which would have granted lawful status to these individuals. Instead, President Obama was able to kind of work within the laws that he has. He can play with the regulations, he can't play with the law. So what he did was create this deferred action specifically granting kind of these permissions for people if they came here and met certain requirements to obtain sort of like a permission to stay. It's temporary. So something that you guys need to realize with this is that it's not a lawful status. It's a 2-year kind of permission to stay, deferred, an action that's deferred. In other words, the action that the government could take is deportation, but they're deferring that action for these individuals. So something that I kind of always highlight for people is that it's not a lawful status. 2, it's good for 2 years. You can renew it after the 2 years ad infinitum until the program is terminated. And then what if the program is terminated? I mean, we could have a different president, and they could decide, you know what, we're not doing this anymore. What's going to happen with those people? It's very possible they could just stay the way that they are now without any sort of permission to stay, just unlawful. And it's also possible, but I think less likely, that the government could decide, you know what, all of you people, we deferred your action, the action of deportation, now we're going to take action. We're going to start deportation proceedings against all of you. I think it's unlikely, because imagine the politician who does that and they only really act in their own interests. But it's possible, and I think that because it's the consequence of that risk is so great that it's something that you should always mention to individuals if you can. Based on deferred action, you can get a work authorization here, you can get a social security number, and you can get a driver's license. So basically, you can live, work, and go to school and be a little, have a little better life here. The next point is immigration history. I like to document every single exit and entry that the individuals had in the United States. Why? Because there are certain reasons the government can decide to deny someone an immigration benefit. Those reasons include if the individual has certain crimes, we'll talk about that in a second, if the individual has come in only once, has stayed here for over a year, and then decides to obtain or apply for permanent residence, if the individual came in several times and then wants to apply for permanent residence, it makes a big difference. And this is under two different sections of the Immigration and Nationality Act. I think one of the more talked about grounds of inadmissibility. Again, inadmissibility is the reason why the government can deny you a visa. So one is Section 212A9C of the Immigration and Nationality Act. 212A9C basically says if the individual comes in or tries to come in and is deported at the border, or is deported, or comes in and is here for over a year, and then, you know what, they decide to go visit their sick grandmother in Canada. They go to Canada, come back unlawfully, and at that point, you know what, they find their loved one. They find the love of their life, and they get married. And suddenly they want to apply for permanent residence. Well, in order to apply for permanent residence, if you have no documentation, generally you have to leave the country and go do it at a U.S. consulate abroad. Well, once they leave, in order to do that, once they leave, then suddenly they get slapped with a 10-year permanent bar for not, in order that they can't apply for permanent residence. Now, I said 10-year and permanent, which is kind of weird, but it means that during those 10 years, you cannot waive that penalty. It's fixed. You're done. And that's a very important thing to know. So going back and forth can often lead to that ground of inadmissibility. There's another ground of inadmissibility, Section 212A9B. Again, these are all in the materials, but that's an easier thing to overcome. That basically says if an individual has been in the United States for over 1 year without documents, doesn't have to have come in unlawfully, but has been in the United States over 1 year, then finds the love of their life and tries to obtain permanent residence, upon leaving, they will get a 10-year bar. Now, it's not a permanent bar, which means that you can waive that penalty in certain circumstances. And that's going to be if you can prove that your parent or spouse, who's a permanent resident or U.S. citizen, will have extreme hardship if you're not able to come to the United States with the permanent residence. So that's the waivable part. That's why it's important to know your exits and entries, because again, just once you come in, stay here, you haven't left, there's possibly a way that we can help you. If you've come in and out, it's going to be substantially harder, and you have that 10-year permanent bar. Next, any prior applications for the individual that you're talking about, or for their parent, or for their spouse. I want to know what applications they filed in the past. Why? Because it can lead to certain benefits. Obviously, if you've applied for something, or if the person that you're seeing has applied for something, we kind of want to know what occurred with that. Were they denied for some reason? Perhaps it was an application for that their spouse did for them that was eventually approved and they just didn't move on with it. Perhaps we can use that. If it was an application that someone did for their parents, that might actually benefit them, even if the person is now an adult. Why? There's a section of the law, Section 245I. Again, it's in the materials. But that says if someone has filed a petition for you, employment-based or family-based, before a certain date, April 30th of 2001, then that individual can apply for permanent residence without leaving. They've got to pay an extra penalty, but that's a possibility. They could either act on that petition if that immigration petition is still valid, if that family-based or employment-based petition is still valid, or they can combine it with another petition that might be valid. So, for example, in the if your parents, if an uncle applied for your parents and put you on the application, well, you might be too old to apply with that petition. But then if you get married to a U.S. citizen, combine the two, and the person doesn't even have to leave the country to obtain their permanent residence. So that's a nice little benefit. So that's why I noted on there. I'm going to flip to the next page. I also want to know any immigration arrests or detentions. Why? Or even at the border. Why? Because any sort of detention could actually be a deportation. Obviously, if they've been deported before, they generally know about it. If they've been arrested for some reason by the local police and then transferred to immigration, they kind of know about it. On occasion, I have people who come to my office who say, well, yeah, I was arrested, and they don't know that there's a difference between the local police and ICE, which is the immigration police basically, and that they were actually deported. So kind of fleshing that story out and talking about that detention is going to be very important. If you were deported in the past, obviously it's going to affect you in your ability to obtain some sort of lawful status or relief in the future. So that's something that we need to know. Also, as of April 1st of 1997, there are different types of deportations. They kind of expanded that definition. If you are stopped at the border trying to come in, on occasion, that could actually be a deportation. Before 97, what was happening was a lot of people were coming in, and the Custom Border Protection CBP they were stopping people, but they were just letting them go back. As of 97, if they stopped you, that might, or they're supposed to deport you at that point, and it's a deportation at the border. You don't see a judge. There is no right to counsel there. It's this kind of la land in the border where the Constitution doesn't apply. So sometimes people don't even know that they've been deported. They just say, "Oh yeah, they caught me, but they let me go. It's just a voluntary return." We check records and we see that it's not. It's an actual deportation. So it's very important to figure that out. Oftentimes we can find out through an FBI check, a fingerprint check. Government records should be on the fingerprint check, so we'll see that they were stopped at the border and the outcome was deportation. On occasion, the FBI isn't totally accurate because for some reason CBP doesn't put it on whatever system they check, and so we need to do a direct FOIA request or Freedom of Information Act request to CBP. Okay, so that's important to know. The next one is fraud or misrepresentation. If someone uses a false document, that can be a ground of inadmissibility. In other words, a ground for which you can't apply for a visa or a status. So if you've ever used a false document, we want to know about it. We want them to be as honest as possible. Sometimes people kind of obscure the truth or don't really tell you exactly what occurred. But if you used a false social security number, that could lead to some issues, some criminal liabilities, in fact. If you used someone else's social security number, even if your cousin said, you know what, go ahead, I'm not working, it doesn't matter, you go ahead and use it, you could both be in trouble. So it's something that we always want to counsel people, be careful with using someone else's social security number, even if it's just to work. Often people go and buy fake social security numbers or fake green cards, that's the LPR card there, to their name. And that's still something that could pose liabilities. If immigration catches you with a false document, that could lead to obviously some, deportation, but also some criminal liabilities. If you've represented yourself to be a U.S. citizen, oddly enough, this is what we call kind of like the death knell of immigration inadmissibilities. If you've declared yourself to be a U.S. citizen, even on an I-9 for a job, and immigration finds out about it, that is a way that you can get into deportation proceedings and obtain a deportation order against you. The deportation based on that ground of inadmissibility is for life. There's really hardly a way to overcome that. Now we can kind of say, well, if they were at the border and someone used a birth certificate to allow this child to come in, only now Are we seeing people kind of being forgiven for that because, gosh, a 2-year-old's not going to really be able to give the birth certificate over to the CBP, but that's only recent. I mean, these laws, these immigration laws can be very draconian. So it's very important to note whether they've committed that misrepresentation. Yes?
So if a potential applicant has committed one of these crimes, do you advise them that they should still try applying, or do you advise them that they should not, because then there's essentially criminal charges coming their way?
Repeat, please.
So the question is, if an individual admits to you that they've committed one of these acts, then is that going to, what kind of advice would I give them? Do they apply for the benefit or do they not? And I generally say no. Obviously, it's going to depend where they are in the process. If they're already in deportation proceedings and we're doing removal defense, then we'll really kind of weigh the options because immigration's already got them. Obviously, you don't want to add another charge to their to the charges of deportation, because if they find out that they've committed U.S. citizen fraud, then you're not just screwing them over. I'm sorry, hurting them. It's hurting them for life. So it depends on the type of inadmissibility. But if you're doing an affirmative application, I usually say let's wait a little bit, and I usually kind of try to flesh it out too with them. And something that I find a lot of lawyers do is that they say, you know what, you can't do this, sorry, goodbye. Instead of saying, you know what, you can't do this because you've done this, these are the potential risks, these are the consequences, so that the individual doesn't just go to some other attorney, might forget to mention this one fact and then apply for a benefit that results in their deportation. So I do suggest, saying, it might not be a good idea to do this because it could lead to this kind of liability.
And what about liability for the attorney that's helping? Is there?
Yeah, I mean, obviously that's the other reason. You want to, you have your ethical duty to tell an individual the consequence. I mean, the way I look at this is that you are counseling them as to well, one, I'm not going to make an application in which there's a lie. So I can't lie in an application and say she didn't commit this type of fraud. Or if there's a specific question, have you ever used a fake document, I'm not going to lie about it. And if I say yes, then that's a liability for them. So we're in a kind of catch-22 where basically I can't do the application for them, and I'm counseling them that they can't. So they can't do it. Obviously, the other bit is, as the attorney in the session, you're telling them what their potential liabilities are. Because, I mean, in my mind, I see a lot of people shopping around for immigration lawyers. The people who come to us are not the most wealthy clients in the world. So they're going to shop around for prices. And so if I tell them you can't do this, goodbye, they're going to shop around for someone else and might forget that one question. So I think it's my duty to tell them what the consequences are. Okay. Immigration court, that's another huge area. I'm sorry, until when do I have?
Top of the hour.
Okay. All right. Immigration court is another big area. If someone is in deportation proceedings, they don't necessarily need an immigration or a lawyer. It's not something that's required like a criminal proceeding where you can get a lawyer if you can't afford one. Immigration law says you can get a lawyer if you want one, but you've got to pay for it. So these immigration laws can be very confusing, and as you can imagine, someone facing these crazy laws is at a loss, even if they just speak English. If someone doesn't even speak English, which is as their first language, which is often the case with people in removal proceedings, then you can imagine the added stress of facing removal proceedings. Now, I'm calling it, by the way, removal proceedings because that is the kind of catch-all term. Deportation is more of the colloquial term and really only for people with status. Deportation proceedings, if they have deportation proceedings, I want to know when it is because that's going to be, of course, very important. If it was the first, if it's the next meeting or the next hearing is the first hearing, or if it's the second or third, or that's why I put other, and how they were placed in deportation proceedings. Why? If it's the first one, generally, generally, the judge will allow the individual a continuance in order to obtain a lawyer, time to get someone to help them. If it's the second, we have two judges that come here, it's Judge Bennett and Judge Sloan, they're generally not going to do that. So if it's the second time, they get a couple months out and then they come in without a lawyer. It's funny, Judge Bennett will always ask, well, do you want more time? But inevitably, if it's the second time, he's always going to say no anyway. But I don't know why he asks. I want to know how they were placed in deportation proceedings. Was it because of a crime? Was it because they were their home was raided? Was it because they applied for something that they didn't have the right to apply for? Because that might be a way that we can attack the reason or the deportation proceeding itself. Maybe there's a motion to suppress or other slew of reasons we can attack it. Criminal history, that's another thing that obviously we want to know. In criminal history, put it down as much information as you can, but also note every single encounter with the police. Doesn't matter if they were convicted or not. I want to know if they were stopped by the police, because often people will say, well, yeah, I was stopped by the police, I got a ticket, it's fine. It's only a traffic ticket. Well, they didn't pay it off, and now they have a warrant for their arrest. That's gonna change the situation. Or often I get people saying, oh yeah, no, I had this one theft conviction, but you know what, it was dismissed, or it was withdrawn, or expunged, or whatever the case may be in their circumstance, and they think it's gone from their record. Unfortunately, for immigration purposes, even if a conviction was expunged, or for some reason maybe there was a rehabilitative statute that allows you to expunge the conviction, it's not really gone for immigration purposes. So it's going to come back and bite them. And so we want to know about everything. Victim-based immigration is another very big reason. Yes?
Do you need to know about crimes in other countries?
Yes. Yes. Any sort of crime anywhere in the world. Important to note. Victim-based immigration is a very big area of immigration law. You have VAWA, which is Violence Against Women Act, not just for women, but also for men and children. There's the U visa, which is for victims of crimes. There's the T visa for victims of trafficking. And there's, of course, asylum. I kind of grouped that in there for people who are scared of going back to their home country. All of the requirements for those different benefits are going to be listed and fleshed out in the materials that I provided. I can't really go through all of that in a minute, but safe to say, we want to know if they've ever been the victim of a crime, if they've ever called the police for help, here or in another country. If you call the police here, the U visa is a very big thing, so I'm going to go in that a little more in detail. If you've been the victim of a crime here in the United States, have been injured in the crime, mentally or physically, have helped the police in the or the prosecutor in the investigation of this crime, then you might possibly obtain this kind of temporary U visa status. It's good for 4 years. On the third year, you can apply for permanent residence. So it's a way to be able to fix your status. The cool thing about the U visa is that it has this really expansive waiver. In other words, a waiver is an application that you can file to forgive grounds of inadmissibility. So remember that dreaded 212A9C or the dreaded U.S. citizen misrepresentation ground. That can actually be forgiven with the U visa. It's one of the very few waivers that can. So I always ask this in cases, and you can't imagine how many people we've been able to save and families we've been able to keep together because of this. So it's something that's important to figure out. All right. Fear of returning to home country is the asylum question. Again, asylum is not, just a few more minutes, asylum is not kind of an easy thing to do. If it's asylum from Mexico, the figures from 2009 say that only 2% of all asylum applications from Mexico were approved. So you can imagine, it's a very difficult application. It is still possible. We have won cases, but it's difficult, and it's based on 5 different grounds. They're all in materials. It's not just based on kind of fear of generalized violence. Well, you can look at that in more detail. Medical hardship or educational hardship. That's something that we want to know about because we might be able to obtain a waiver. Again, that waiver that we're talking about, there are different types of waivers. Waivers can be based on hardship to a U.S. citizen, parent or spouse, or kids, and it depends on the situation, not all of those included, but it depends on each waiver. So we want to know hardship to each of those individuals in case we can talk about that. All right, I talked really fast. I wanted to get as much as possible in here. I'm sorry if it was a big whirlwind. Do we have time for like a few questions or questions? Perhaps no questions. Yes?
Background, the background checks that you're talking about, the Information Act and all that. It seems like you'd want to get that pretty much on every client that you've got.
Yes, background.
How expensive is that? Yeah.
Oh, like the FBI checks?
Yeah.
I generally do FBI for a lot of people. If they say they've only lived in Idaho, then we can do a local check here. Then it's a little easier. But I mean, it depends on the type of visa and the type of application that you're filing. If it's a U visa, for example, it's a little easier to forgive crimes unless they're huge major crimes like drug trafficking or murder. Forget about that if you're a murderer. But I would get an extensive background check on everyone. Yeah.
As far as for terms of what we're going to be doing.
Ask them.
Ask them, but I mean, you're going to still need to get the background check. And how much is the background check?
It's FBI is
How
$18.
easy is it for them to do it?
It's not very hard. You can go to the police station and do it, and many people are scared of doing that, but it's really not an issue to do. We do it in office often. We just send in the fingerprints and $18. But for the purposes of the clinic or the street law clinic, I would say talk to them and tell them why you're doing it. I mean, say, look, we want to know absolutely everything because we're going to be able to give you better counsel on what you can do and what you can't do. If you have any sort of run-in with the police, dig back in your memory and try to let me know what happened. And then, depending on people generally, I mean, you kind of remember when you've been stopped by the police, I would hope. Funny thing, though, I've had clients who are like, oh, yeah, no, there was that one time I was stopped and it turned out to be a drug conviction. But, it's not kidding you, not just one time. We're at the mercy of their recollection at this point, and that's just the best that we can do, unfortunately. There's no system where we can, access the database and get an immediate background check. But FBI is going to be the best bet.
Is the website that you were referring to the ITLA website where this information is located, or some other website?
No, Quinn should have the information that I've drafted up. I've put more resources in that information that you can access. USCIS. Go to the regulations, the INA, the EOIR, the Immigration Court website. So you can figure that out.
What if somebody's been using different names? Is that very difficult? That seems like it's really difficult. Repeat.
If someone's used different names, how is that going to affect their situation? Obviously, I've had many people who use different names for work or for employment. I had someone who came in and used their brother's name, obtained a permanent residence, and now a life under the brother's name. And it's difficult because now I can't apply. He's a U.S. citizen now, and now I can't apply. I had to, I had to withdraw from the case because he wanted to file a petition for his wife. But I can't because now I'm going to have to put down his name. And now I know what his real name is, and that's not the name that he's giving me. So it could pose a big problem. I would ask them from the get-go, and sometimes clients won't tell you, and this is what happened in this case. Ask them for all of their names, any names they've ever used. The immigration applications will sometimes ask that. And they will be hesitant because sometimes they'll say, oh, I was arrested under this name. Well, guess what? Immigration is going to do a fingerprint check, and you can't change your fingerprints. So they're going to catch you. That's another reason why we need to know.
So that's why will the fingerprint catch all the names, or do you have to do a background search on all the different names?
The fingerprints should catch all the names that they've used with and have been caught for a crime. It won't catch the names if they used it on an I-9. So we're at the client's mercy for them to tell us. But at that point, if they don't tell us, and there are many savvy clients who come to me and don't tell me, this one this one client who tried the U.S. citizen who tried to apply for his spouse, I told them, look, I can't put your fake name on the application. He's like, well, I just happened to tell you in passing that this happened. I mean, why can't you help me? Well, I'm lying. I'm not going to put my license at risk. Unfortunately, I can't help you. But he could turn around, and there's no evidence that he's this other person. He can turn around and go to some other lawyer and just not mention that his real name is whatever it was. And that's probably what he did, unfortunately. But there's nothing I can do about that. All right.
Thanks so much.
Thank you.
So next we have, next we're going to do landlord and tenant law. A mentor of mine and a hero of mine and someone fresh off of a wonderful victory at the Idaho Supreme Court. Mike McCarthy drove all the way from Twin Falls, and here he is.
Okay, thank you.
Got till 9:40.
Thanks. Jeez, I don't know if I can live up to that. Billing. So basically, as I'm going to talk to you about, as for landlord-tenant and issues, and if you look at the intake sheet that I gave you, this was just done off the top of my head. So, and I noticed that I really didn't ever cite the Idaho Code at all, but pretty much everything you really need to know about basic landlord-tenant law, you need to look at 6-300, 302, 310. Those are the main statutes. You need to look at that statute if you're, even if it's just, and I even find after doing this for a long time, I'll still go back and read through and realize, oh, I haven't thought about using like this provision. But the main thing in a landlord-tenant case, it sounds really basic, but people, you just have to find this information out. Do they have anything in writing? You know, how much is their rent? Where are they in the process? And I think the biggest thing, especially if you're just doing advice in a counsel and advice clinic type situation, they just want a basic answer to their question of procedurally, they want to know where they are in terms of procedure. And you can do a lot to alleviate a lot of their concerns because there's lots of misinformation out there. You know, there's snow on the ground, you noticed this morning. You'll hear that. I mean, probably the first day you talk to someone, you'll hear, especially if it's wintertime, well, there's snow on the ground, I have little kids, they can't evict me, right? I mean, that's, and a lot of all you're doing is just telling people, no, that's, you know, one of these great myths of the law that's out there. Because there is a provision for utilities that are regulated by the Public Utilities Commission, mainly power, that they can't shut off your electricity during the moratorium period, which over the years, I've been doing this long enough, I've seen that period of time shrink from about 4 or 5 months to like 2 months, but that's another issue. Or anyways, but basically, people want to know, can the landlord lock me out? Can I be locked out? Can he cut off my water? Can he come over and kick me out? Can he come over with a shotgun and kick me out, which I had happen in one of my cases, a case out of Castle Ford, so I don't know. Anyways, but that happens, and it does even happen in Boise because I did the hotline, and the cases were just as crazy. I used to do the hotline for legal aid for a couple of years, and the cases were just as crazy out of Boise as they were out of, you know, Twin Falls and in the rural areas. So anyways, you'll see all kinds. But getting back, I guess I'm getting off my outline and just ranting and raving. But you want to find out how much they're behind in rent, because that's key. It's very important to distinguish rent, late fees, utilities. You want to get the basic structure of their rental agreement. And quite often they will have something in writing if they remember to bring it to the interview. But quite often they'll say, yeah, I did sign something, but it's all with all those other papers that I did for my Social Security application I can't find, or something like that. But it's really important to find out what is rent and what is not rent, because the remedies the landlord has are dependent on whether he's evicting solely for rent or if he's including other things. So Basically, once you get past that, okay, do you have a written lease agreement? How long? And I always find it's best to kind of go back to the beginning and say, when did you first rent? How much was it? What were your terms? And even if they're verbal terms, sometimes you're dealing with that. But usually what's happening is they're being evicted and they're afraid about being locked out and they want to know procedure. So if they're behind in rent, you want to look at their notice. Have they been given a 3-day notice? That's the key. A lot of times folks will be, how were they given the notice? And a lot of times folks will be concerned, well, the notice wasn't given to me by a cop or a sheriff, so it's not valid. Or the notice was taped to my door, so it's not valid, so I can just ignore it. Or the notice is handwritten, so it can't be valid, it's not notarized. That doesn't matter. I mean, if you look at Idaho law, it does have to be served correctly under Idaho law, but it can be handed to you by anybody over the age of 18 is valid. It can be taped to the door, which is an interesting question if the person never saw it or blew away before they saw it. But basically, the notice can be taped to the door. But then you look at what the terms of the notice are, and it's very important that the notice, if they're going to use the summary eviction proceedings, the notice has to give them the option to pay or quit. So that's very important if they're going to use the summary proceedings. And by that I mean there's a summary action that a landlord can bring that happens very quickly. And so you need to be familiar with that action. It's Idaho Code 6-310. And it's taken a long time, but I think over the years we finally got the judges educated to where they will accept that argument that that is solely limited to non-payment of rent cases only. And so that's why it's very important, because in that action the tenant is not able to raise any defenses other than whether they did or didn't pay the rent. And they're not able to raise counterclaims. They're not able to counterclaim for the landlord's failure to make repairs. So it's really important to make that distinction, because you can get cases dismissed on the grounds that they're including things that like late fees. They're trying to evict for that. Then you look at the notice itself and how it's worded, and you look at the amount. And like I said, if it's including things that aren't rent, like late fees or utilities, that are the tenant's responsible for, and that amount is in, then the notice is defective. And I think, in theory, then the whole case should be dismissed at that point, because the thing that gives the landlord the standing to bring the action is defective. So some judges will accept that, some judges won't, and then you're kind of stuck, your client's being evicted, what do you do next? But if you're just giving them brief advice, you can at least tell them your notice is defective. When you go to court on this, point that out, ask to be sworn in, go try to tell the judge that, how that actually works in the real world. If you've ever seen like a landlord-tenant, like in Boise, I think there's one day where all the evictions are, like Wednesdays, I think, and there's a whole bunch of them. And like in Twin Falls, they only schedule like 15 minutes for these. So if you show up with like 4 witnesses and you want to have a whole day trial, that's sort of an issue that's got to be resolved somehow or other. Whether some judges are okay with that, some judges will try to, anyways, some judges will continue. You have a right, anyways, we'll talk about that in a sec, about your right to a continuance. So I tend to ramble around, as you notice, so I'm not the most, direct kind of presenter in this circumstance. So I think if something pops into my head and I think, oh, I remember that case, and so I start talking about it. So I get it. Anyways, I think we've gone to the next. So what these people want to know, though, is procedure. I mean, they want to know, so he can't come. So after the 3 days ends, they always want to know, how do you count the 3 days? So, and I think that's I don't think there's too much controversy about that it's only business days. I mean, the Idaho rules, civil procedures say if it's less than 5, then you only count business days. So if they serve it to you on Friday, Friday doesn't count, so you have Monday, Tuesday, and Wednesday are your 3 days. So the first day they can file an action is Thursday. And so this is, I find people do, I think, get a lot of relief when you kind of explain how this is going to work. Because even just those 3 days, and then they say, okay, what happens at the end of those 3 days? It doesn't mean the landlord can come over with his shotgun and boot you out or lock your doors or change your locks. That's an illegal eviction. Self-help eviction is illegal. It's not a valid, to evict someone legally, a person has to get a court order, has to go to court, get an order, get a writ of possession, which is the order, the writ from the court to the sheriff telling him to change, to forcibly remove the people. So those steps, so anything short of that, in my opinion, is an illegal eviction. And basically what you're doing is trying to ensure that they get procedural due process in the minimum amount. And I think the Idaho Code sets out the minimal amount. So they can file an eviction. If it's an eviction in a summary action, then that's a special proceeding that can be heard on 5 days' notice. So once again, going back to our example, you're served the 3-day pay or quit on Friday. So Monday or Saturday and Sunday don't count, Monday, Tuesday, Wednesday. So Thursday they can file. So then they can file their action on Thursday, but they have to give 5 days notice of the trial setting. And so the trial cannot be set. So once again, you have to count 5 business days from that day. So if they're served Thursday afternoon, then they could be served for a trial that would be like the following Friday. Because if you think, that would give you, you're served on Thursday, so you get Friday, Monday, Tuesday, Wednesday, and Thursday. So there's your 5 days. So the trial could take place Friday morning, but the tenant can ask for 2 days. There's a provision for a 2 days worth of continuance. That's sort of, I don't know how, I've only seen it come up in a couple cases, but and I don't know how liberal judges are in granting that, but there is the provision in there for 2 days, sort of. But what happens kind of in the real world is the judges' calendars don't generally work such that you can do this in the time period. I mean, basically, because like I said, in Ada County, I think it's Wednesdays. So basically, to get on, and then on the calendar fills up those Wednesdays. So it may be 14 days out. And so when the person comes to see you in the, sitting in the clinic, they may have the summons and complaint, and they maybe say, I got court, a week from now. And so then you do all this stuff backwards. I mean, if you're sitting there, with somebody, you kind of analyze, did they get the right notice? Was that served right? Is this notice right? There's a specific summons for a notice of trial setting. And back when I first started doing this stuff, we didn't have this specific summons, and it was kind of unclear how this proceeded. And so people would get like a regular summons telling them they have 20 days to answer, and then they would get this separate document called a notice of trial setting or something like that said the trial's going to be, on this day. And so basically, a few years ago, the court issued this separate summons, but you still see those cases where the person will have the wrong summons, and they'll get a summons telling you got. So anyways, you have to look at that, because that's a pretty good, that's something you can get the case dismissed on. And I guess, my basic philosophy in landlord-tenant law, I represent tenants, so my philosophy is, I'm trying to buy people time. I mean, generally, it's kind of a no-brainer if they haven't paid the rent, that they're probably going to lose at some point. And you're going to run into judges who are kind of antagonistic to your basic position anyway if they haven't paid. So you're making all these great procedural constitutional arguments, but the things that work, I mean, that goes to the heart of the system of having a defective summons, not getting the 5 days. Oftentimes I've seen cases where people just don't get the 5 days because the landlords are in a hurry to get these people out. And so, they'll only get like 4 days. And oftentimes, one thing you'll see more and more of these days because of the court assistance office, are that the landlords are often pro se. And they get the forms from the court assistance office. They get the 3-day notice to quit, I think off a legal aid's website as much as anything, or the court assistance. And then their pleadings generally come from the court assistance office. So that's good and bad. I mean, but quite often these folks, they're not lawyers, and they do make some mistakes that are pretty, that you can use to get their case, the person's case dismissed. But assuming, the other thing you want to look at, I didn't really, I guess these are basic questions, but I kind of stopped. I don't know what happened. I probably just lost track and started watching TV or something when I was writing this. But anyways, I mean, the next thing is when they do go to court. This is something that the people really stress about. What happens when the court says, okay, you're evicted? You know, how much time do I have? And some people will tell you, I got 48 hours. You know, clients come up with this stuff. I get 48 hours. You know, I heard that on some TV show or something, that I get 48 hours, or the sheriff. You know, sometimes they'll say, sheriff told me I had this much time, or the sheriff usually doesn't tell them positive information. The sheriff usually tells them negative information, or stuff that's not helpful to them. But basically, there is no law on that. So it's just basically how quick can the landlord get the order entered, and how quick can they get the writ of possession, and how quick. So, but most landlords and most lawyers who represent landlords who are reasonable, they understand that, you know, the person may need a little time. But basically, when you're advising somebody, you have to tell them, if your court is like next tomorrow, you may need to get your stuff out tonight, because you may not have that much time. I mean, I've had judges I had one judge once call me, say, like the next day after court, and say, your client's still in there. Tell him to get the hell out of there, you know. And it's kind of weird, the judge calling me to tell me that. But basically, this was somebody who's now on the Supreme Court, so for whatever that's worth. But so anyways, but basically they don't really have. I mean, some landlords are okay, like, give us 24 hours. Sometimes, like, I tell clients that, you know, or if I'm representing a client, and I'll just be up front with the other attorney and say, he doesn't have anything, but could you give him a day or two? For them to physically have the sheriff move their stuff, they have to post a bond. It costs them lots of money. It's a hassle. So if giving the person 24 hours, you know, to get their stuff out or entering an order, I mean, the thing is, the tenant is more likely to get their stuff out and to not be a pain in the neck about it and not trash the place if they think they're getting something, even if it's 24 hours to move. And so oftentimes they'll be more willing to buy into it and not be a difficulty. But so usually the good landlords and the good attorneys for landlords will kind of give you that much time. But the reality and the law is there's no, you know, as soon as they get the order, they're free to do it. I mean, I just did one the other day where within about 4 hours of court, the locks were changed, and the sheriff was out there, and they let the guy go in and grab some stuff. But and anyways, this guy didn't really listen to me very well because I had basically told him he was going to lose, and that's why I didn't even bother. I didn't go to court with him. I told him, you know, I represented him in an earlier eviction that we won, so he thought I was a really good lawyer. And then as they refiled and did it all right, and I said, so I told him, I'm not going to court on this one. I mean, you're done. But he didn't understand that he could lose, I guess. So anyways, so he was, but basically, you know, so he had to kind of negotiate to get his stuff. I mean, once they're locked out, there's no reason the landlord keeps their stuff. There's no such thing as a landlord's lien, or some landlords will say that. Well, he owes me all this money for rent, so I'm going to hang on to his mattresses and his kids' clothes and their toys until he pays the rent. Well, there's no such thing as that. I mean, that's basically executing on property before you have a judgment. It's claim and delivery. The action you can do, you know, it's conversion of the property. And so you can get into like claim, the action is claim and delivery and conversion. And sometimes you end up in those kinds of cases where you have to litigate those kinds of things. So basically you got to tell your client though, there's no guarantee how much time you have. You need to get your stuff out. But a lot of times, just telling people, laying that out, you get the 3 days, then you get the 5 days, and the reality is you're probably looking at more like 10 days, because once you get everything done, and landlords aren't usually real on the ball. I mean, they'll give that 3-day notice thinking that'll get them, you know, and then they'll kind of wait a couple days after that. And because a lot of landlords are really tightwads, you know, and they just don't want to spend the money to evict somebody. So there's that. But if it's not a non-payment of rent situation, then they have to follow normal procedures. And then you can end up in like litigation that drags on. And like I have some cases where, you know, they give the 30-day notice that we're not going to renew your lease. Generally, if your lease doesn't have a specific provision, if you pay by the month, then they can give you a 30-day notice, I'm not going to renew, and then the person holds over. And the landlord then has to bring some kind of action to have them evicted in the normal process, and then you can bring like counterclaims. And you can end up litigating those cases for a pretty long time, and as long as your person keeps paying the rent, like a lot of times a landlord will not renew a lease because they say you've violated the lease in some provision, and your client will deny they violated. And this comes up a lot in the public housing context, because landlords generally have to have good cause to not renew a lease if it's a public housing, if it's a HUD-assisted housing or FMHA. And so a lot of times you know, and I look at it like, so as long as your client keeps paying, they can, you know, they can't use the summary actions. They have to go to court. They have to prove this. And so you can counterclaim for like if they violated your client under the Fair Housing Act or stuff like that. And so you can end up, you know, being months. I have one case. I don't understand why the other attorney hasn't asked the court to set it for trial, because I would think he's the one who wants to get my person out. But we're literally 6-7 months into this, and he still hasn't asked the court to even set it for a trial. And the judge hasn't figured out, I guess, that it's on his calendar. But I look at that as winning, you know, from my perspective, as, you know, representing tenants, as long as I'm, you know, keeping them in there. So I guess that's pretty much all I would say on, I did enclose a thing about repairs, because those seem to be the two main areas. Repairs are, the tenants will contact you for repairs. And the repairs, the important thing about, if you look at 6-320 is the statute that has the warranty of essentially the warranty of habitability, that a landlord has a duty to provide, you know, working plumbing, working weatherproofing, working electrical. There's some other things in there, and I listed. But basically, you can ask, were you in any way responsible for the condition? That kind of comes up in the bed bug situation a lot. Is like, who brought the bed, you know, where'd the bed bugs come from? Did they sneak under the door from the neighbor, or did you bring them, you know, were they there when you first moved in? And that's kind of, I've had some issues with that about the bed bugs. So, I mean, I generally take the position the landlord's got to fix it regardless. It doesn't do them any good to not try to fix it anyway, but sometimes you can convince them of that even if my client is responsible, which I deny, what good are you doing to fight us on this, about this? I mean, why don't you just fix it? Go ahead.
Well, people, when they ask if they can withhold rent for the failures to repair,
No.
is it only like a smoke detector?
Yeah.
There's no working smoke detectors, and they can withhold the amount that it costs.
And the only reason you can do it in the smoke detector situation is because it's specifically authorized, I think, in the statute. But that's a good question, because that comes up a lot. The duty to pay rent and the duty to make repairs are independent covenants. I think there's case law that says that. Like in Montana, in California, I think you can do that, and I think that's why there is kind of a lot. That gets into the atmosphere that you can do that, and you don't. And you always want to keep paying rent, because that summary eviction is such a strong remedy that a landlord has, is that, you know, if you're going to pay, you know, pay the rent first and don't pay the late fees. If you can only tender, so yeah. Anyone? Yeah.
Can the landlord, in the summary action, can the landlord go for eviction and also for past due rents? I mean,
No.
get a judgment for rents? Okay.
No, landlord is specifically prohibited from doing that. And you can ask the court to dismiss the proceedings or something, or at least make it a non-summary action if they want to do that. Or I don't think, though, they're not barred from trying to collect later, because it, I think, is the case law or the law that they can bring a later action for the unpaid rent. They can get their attorney's fees, though. And that's something, you know, some lawyers, I think, I don't know, but usually the realistic lawyers and landlords, they you know, trying to chase down the attorney's fees and stuff, and the unpaid rent often is pretty tough, because a lot.
If these guys aren't paying rent, how are you getting paid?
Payment up front.
Yeah, but
Well, I'm usually representing tenants, and I work for Idaho Legal Aid Services, so I don't quite have that concern. So, yeah, I mean, I think landlords, but I mean, I think the good landlords attorneys that I see, they do it, you know, they have it down, they know how to do it, and they get it, they kind of get in and get out and get it done and get the person's property back, and I think that works out best for everybody in some ways. It's when, anyways.
Can you use the summary proceeding in commercial property?
I don't know. I think so. I guess Richie's nodding his head yes. I never really thought about it. I had one case, like in all my years, where my client had like a business and they did it, but I'm not.
And the other question is, once they've been evicted, does the landlord have to go and do a writ, or can he then take self-help measures?
I think he has to get a writ. I think if he doesn't, I think that's the way he has to do
You
it.
have to go and take a writ and take it to the sheriff. You have to use the sheriff's office.
I think so, unless if the tenant is not voluntarily
So
complying.
they can't go down there and just change the law themselves and try to, or do something like that.
Well, I think they'd go change the locks once they got a court order. I think. What do you think? You don't think so? Okay. Well, you think the sheriff, they have to have a writ first, or?
I think they would have to get the people out before they change the locks, because otherwise they're dispossessing them.
The judge has already signed an eviction order. That's where I was confused about.
He's already signed an eviction order and issued a
And actually signed-
issued a writ, and then you have the sheriff come and boot the people out, but their stuff is still in there. I mean, that's what happened the other day in this case I had.
And you got the problem with conversion.
Yeah. I mean, Richie's probably right. I mean, that probably is, you probably have, like Richie said, I think you get rid of the people, you have to get the people out first, probably before you do physically change their locks, but in the real world, I don't know. I know how it kind of works out. It ends up getting worked out. It's sort of what happens a lot of times. It happens so fast. But anyways.
In our experience with our apartments, once you get a court order, you have to take it to the sheriff's department, and then they come over and they serve it, and they will actually have the people move. But if the people aren't ready to move, you, as the landlord, you may have to hire a moving agency.
Don't you have to like post a bond with the sheriff? Because essentially, isn't it the sheriff who's actually hiring the moving company, and then they take it to some, which can run into
the
money.
landlord pays the bill for it until those people pay to get that.
What I have found is the law enforcement people act really tough and tell people, you got to get out of here right now, and they're really intense, you know, and try to scare them. And I think the landlords try to scare them, and so it seems like maybe you see this more in Boise than we do in our area, where people usually get the message by that time, and you know that they need to go. So, all right, thanks.
One last one.
Oh.
Do you deal with housing discrimination at all?
Yes.
I mean, is there any resources for having that in mind?
Well, there's there is the Intermountain Fair Housing Council is an agency that's their specific, mission is to. We sometimes bring up those issues. I mean, like the Fair Housing Act has provisions for reasonable accommodations. So sometimes we'll use like a request for a reasonable accommodation as a grounds for fighting an eviction, or But it comes up a fair amount, I mean, or with our clientele. But I guess I'm not, yeah. I mean, we use it a lot, but I just don't know.
I was going to comment. If you're working under the HUD statutes, that's a whole different beast than just I have a rental agreement and I've gotten an eviction. So
Yeah, that's.
I think his question is
Oh.
a very big question, and it encompasses a lot more than just the Idaho code.
Well, the Fair Housing Act, you know, is a federal law, and it applies to both, you know, private and public housing. But in a public housing situation, you have so many more rights. I mean, you have this lease agreement that incorporates, you know, a lot of regulations. And you basically have this whole good cause standard of eviction. And whereas in the private situation, it's pretty much did you pay or not. And so, but the federal law overlays all of that. And if you can prove they should have given, you know, they should have given me an accommodation, like, you know, I don't know. I had a guy who was sort of, because of his mental disability, he was a little scary to his fellow tenants. He wasn't really that scary, but he lived in a place with a lot of elderly people mostly. And we kind of used that to argue, you know, they should accommodate that disability, give him a little more leeway. And I don't know how that would have come out if we ended up trying it, but it actually was a good way to get that case settled and stop them from evicting him. So I've used it. I mean, it comes up all the time. I mean, you got to think about that federal law all the time because it's always there, and landlords need to know about it probably more than the tenants. But, yeah.
If you've got a tenant that's under a lease that has a no drug policy, and they get arrested for possession or distribution or something out of their home, but they've been charged anything, can they be evicted under that, or do they, until they're guilty? Under
Well, I forget how the statute is written. I didn't mention that. The summary action is also available for, I just focus on non-payment of rent, but the summary, you can use the summary action for having marijuana in the household or having drugs. It's sort of like, I don't think it's based on whether there's controlled substances in the house or something like that. And so I think that burden would be on the landlord to prove this was happening. I don't think the fact someone's charged or is enough. I mean, they still have that basic burden of proving the facts. But I can't remember how the statute is written. But there is, I think it's 310 where they define the circumstances under which you can use that. So.
How far behind in rent does someone have to be?
Right away. I mean, as soon as you're behind, they have grounds to, unless, I mean, that's where getting back to getting the written lease agreement. I mean, unless their lease says something like you have, and sometimes leases will have kind of a grace period, but most of them, it's rent is due on the first day of the month, and if you don't pay, you know, we can bring an eviction action against you right away.
So if they don't have a written lease, there's not like a general rule of thumb they have to be 30 days or something like that?
Just then, if they don't have a written lease, then it's kind of whatever their verbal agreement was, which is if there isn't one, and so, you know, you may have a guy who said, he always told me I'd have till the 15th, and, you know, the landlord's saying, no, it's the 1st, and then a judge might have to, you know, make a decision. Or if there's, a lot of times if they've never thought about it, then the court, you know, you go back to contract law, they have to imply terms and, you know, so what's reasonable, and so, yeah. Okay, you're welcome.
So Mike's graciously agreed to come back later, and he's going to talk about, yeah, by the way, this thing's apparently too cool for the video, so we're turning it off. Of course, I don't know how to do it. All right. So next, coming out of the green room is Mark Manweiler. You can just look at his thing in his program. I think he's best lawyer in the world, top corporate lawyer in America. Always insightful, always entertaining. Going to talk about criminal law and some other things.
Thanks, Richie. I'm old school, so no PowerPoint, but here's a brief outline with attachments. Good morning, everybody. Time is obviously short. Hopefully I won't break John's camera there. You've seen me before. I normally start these presentations off with a lawyer joke, but I don't have enough time, so all I'll say is there's still time for medical school if you guys are reconsidering. I've got 3 topics to kind of cram in here in 30 minutes, so I'm going to try to blast through them fairly quickly and leave some time for questions at the end. My first topic is criminal law. You're going to probably run into this quite a bit in the street law clinic, at least either straight up or related to some of the civil issues. Key fact to remember about criminal law is 90% of the people charged with crimes are really guilty. That's the way you got to start out looking at it. And the question, obviously, as a lawyer is not did they do it, but what can the state prove with admissible evidence? If you can suppress all the dope, it doesn't matter if they did it, they have no evidence. So you want to be looking at it with a clinical eye in terms of what the state knows, what they can prove, what they still need to prove out to prove the material elements of whatever offense is under investigation. By far, the most important rule in criminal law is right off the bat, when somebody comes in and says, hey, I'm under investigation, the detective wants me to come down and talk to him, that's a big no-no. The one thing you never want to do is talk to the police until the client has talked to you first. So there's few absolutes in the law. But one of them is, until you talk to your client, you always tell them not to make any statements to law enforcement. The other thing is, in the digital age, the cops aren't stupid. They go after cell phone records. They can ping the cell phone towers and find out where your client was when, Facebook, MySpace, all that stuff. So you need to also advise your clients to be careful about digital information sources. And I'm going to talk about that a little more in a minute. You're going to get the good cop, bad cop routine. Sometimes clients will come in and see you after they've already been initially interviewed, which, you know, is too bad. It's better to get a hold of them before they talk to the police. But police are trained to extract incriminating information at these interviews, either in the form of confessions or in the form of getting your clients to make a statement that they can prove is wrong, and thereby prove your client's not credible about some of the other statements. The good cop, bad cop technique is a really common one where one cop comes in and says, hey, we think this is a bullshit investigation. We just want to get your side of the story and get our file closed up. And then you have bad cop that comes in and really leans on them. It's very common for police to represent to clients that they've already kind of figured out that there's no crime here. They just need to finish up the paperwork for the file. Same thing when cops pull people over and they want to give you a field sobriety test. They say, hey, just want to make sure you're okay to drive. I'm just here to help you out. And that, of course, isn't really what's going on. One thing to make sure your clients understand is the permissible deception doctrine. Police officers are not officers of the court. They are constitutionally allowed by the U.S. Supreme Court to lie to suspects. The classic example of that is they go to a burglary and they see that the MO is a particular way of breaking in, and they know that this MO matches Johnny Smith's MO, and Johnny's recently out on parole. They can go to Johnny Smith and lie to Johnny Smith and say, we've got your prints. You may as well confess and make it easy on us, even if they don't have his prints. That's totally legal. So police officers are not like prosecutors. They are totally allowed to lie to people, and they do it all the time. It's a perfectly constitutionally permitted investigative technique. So don't expect that cops always are going to tell the truth to alleged suspects. There's 2 schools of thought on whether you want your client to tell you everything or not. I'm of the school of thought I want to know every single thing there is. I think it's much better to know what your client really did so you can correctly, legally analyze issues of admissibility of the evidence and give your client good strategy advice. And I always tell my clients, if I go into court and I step on a landmine, it blows your leg off, not mine. I don't think there's much credence in the argument that you should tell your client not to tell you if they really did it or not for the sole purpose of being able to ethically put them on the stand and let them commit perjury. I don't think that gets you anywhere. I think it hurts your client. I tell my clients, tell me everything. I want to know everything. I'm not going to judge you. I'm a legal technician. I can give you maximum good advice if I have maximum qualitative and quantitative data. That's just after doing it for 30 years, I'm firmly convinced that's the best way to go. There are some cases where, let's face it, your guy's totally guilty and they can easily prove it. And so the best thing you can do for your clients, get them the best sentencing deal you can get. And that's your job at that point. So I tell them to tell the truth. Now, when do you allow your client to talk to the police? Here's my rules. One, after you interview your client, and hopefully after you've seen as much stuff from the cops as you can get, and oftentimes you're not going to have the police reports, the witness statements, the physical evidence. You're going to have to make this decision. Your client, there's a typical scenario. Client calls and says, detective has called and said, my niece says I sexually fondled her. They want me to come in and talk to them. First thing you do is you tell your client not to talk to the police. You make an appointment. The client comes in, you talk to them. You get their full side of the story, and you make an assessment as to whether or not you think the guy or gal is factually innocent. The next thing you want to know is, are there any other parasitic crimes that the police may be investigating that your client doesn't know about? Next thing, I don't let my clients talk to the cops even if I think they're innocent, if they're idiots. If they're stupid, if they're developmentally disabled, if they have some cognitive problem, if they are emotionally freaked out and on psychotropic meds, I don't care if they're innocent or not. It's not a good proposition to interview with the police. Obviously, you want to make sure if you're doing a police interview, you're there and you're controlling the interview, and you want to record it. In state court, most of the police officers and detectives record the interviews. In federal court, the FBI is trained not to record it. What they do is they make sure if there's you and your client in the room, there are 3 FBI agents in the room. If there's you and your client and another lawyer, they have 4 FBI agents in the room, and they just write up a paraphrase report called a 302 form where they paraphrase what your client told them in the interview. I record it anyway, and if the FBI agents say, we don't let you record, I say you don't get an interview then because the facts are important. I don't want any mistakes. So if you're going to interview, you want to have an innocent client. You want to have a client smart enough to deal with interviews. The cops are evaluating their subjective body language as well. You want to be there and you want to record it. The only other way you want to interview is if you get immunity. You probably know from law school there are 2 basic types of immunity. Use immunity, which means the police officers can't use the statements your clients make against them in the investigation unless they can obtain that evidence through independent sources. Transactional immunity means they can't use the statements against your client, period, no matter what. Your client can get in there on a drug case and say, I killed Jimmy Hoffa, and they can't use it. They rarely give you transactional immunity, but that's the gold standard. That's what you want to try to get. Final thing on interviews, don't be afraid to pull the plug and stop them. The main problem with these things is you don't know what the cops know when you go in. All you know is what your client told you and what your client's been told by the police. You don't know what other evidence the police have. So if it starts to smell bad or feel bad, stop it. You can always tell your client to come out in the hall and talk to you before he answers a question or she answers a question if you're not sure exactly what to do. Other thing, Facebook, MySpace, the police officers and the prosecutor's office check these things like crazy. And I'm always asked the question, does it a destruction of evidence to tell your client to take incriminating stuff off Facebook? Classic example, teenage kids with drugs, alcohol, gang signs, stuff like that. I think because Facebook can always be rebuilt, just like the police can come and reconstitute your hard drive after you've deleted things and put them in the trash, I don't see it as a destruction of evidence issue. But if my client comes to me, I always tell them, look, the police are going to look at your Facebook. If you have everything on there that's bad, take it off. That's my view. Some people disagree with that. Second most important rule, in cases where there's no strong physical evidence, like a fondling case as opposed to a penetration case in the sexual context, one of the things the police always do is ask the suspect for a polygraph. Their policy is not to polygraph the alleged victim, or what I call the complaining witness. I never let my clients do a police polygraph till I have them take my guy's private polygraph. I use an ex-cop that does them. I want to know for sure the guy's going to pass the polygraph before we go take the police polygraph. If you use a credible private polygrapher, oftentimes your client passing that polygraph will be enough to end the investigation right there, and they won't even ask for the police polygraph. But clearly, you don't want to submit to a polygraph unless you know your client's going to pass it. The only way to know your client's going to pass it is to have him or her take a private polygraph first. Yes?
Is that private polygraph discoverable?
No, it's work product. It's attorney work product, and that's what the contract says, because I hired the polygrapher, not the client. Good question, though. Final item. Even though your clients are told when they make a phone call out of jail that it's being recorded, for some reason they don't believe or comprehend this. So hammer your in-custody clients with the fact that everything they say in jail is recorded. All the letters they send are copied. The only exception to that is attorney-client communications. People don't get this. And they also have online visitations, Skyping basically at the jail, where people can talk to their friends or relatives. It's all recorded. So when they badmouth the prosecutor or the judge or the cops, it gets shoved right down their throat later. And people just don't get this. Okay, that's the quick down and dirty on criminal law. Let's talk about restraining orders. People oftentimes will come in and say, I want a restraining order against so-and-so. Well, you can't always get one. That's the simple answer. Right now in Idaho, there's 4 basic ways to get a restraining order. I've attached exhibits that cover all this, but I'm going to run through it just to kind of give you a flavor for it. The first way is what I call the old way. When I started practicing law 30 years ago, this was the only way, and that was a classic Rule 65 temporary restraining order. To get one of those, you got to file a civil case, first of all. There's got to be a pending action, or you can't get one. You have to allege irreparable and immediate injury, loss, property damage, economic loss, and you have to allege it under oath by specific facts. That order, that temporary restraining order, should the judge grant it, and these could be granted ex parte in chambers without the other side being present, although you have to tell the judge what efforts you've made, if any, to contact the other side, especially if you know they're represented by counsel. That order is only good for 14 days. It either expires automatically, or you got to go back and have a hearing with notice and opportunity for the other side to appear to convert it into what's called a preliminary injunction. And of course, there's ways to convert it to a permanent injunction later on down the road after a full-blown trial. But keep in mind that these are the kind of orders you use in general business situations. People are going to waste assets. The other side can ask that your client post a bond, so if the allegations your client makes turn out not to be true and the issuance of the temporary restraining order has cost the other side economic loss, they get compensated by the bond. That's the classic defense against these, is to go in and say, Judge, go ahead and give him the order. We just want him to post a $100,000 bond, so if it turns out to be bullshit, we get our money back, okay? Next type of restraining orders, automatic family law. I call them divorce, joint temporary restraining orders. Every county in the state has a different version of these, okay? The versions, the exhibits 2 and 3 are the ones I've attached for Ada County. Canyon County's got a different, shorter, more compact version. All the counties you may do divorce work in have a little different version of these. But anytime you file a divorce in Idaho or a paternity case, okay, the court in the county you file it are generally going to automatically issue these joint TROs. In the divorce context, you're going to get 2 TROs, one that deals with property and one that deals with children if there are kids. If it's just a property-only case, the court obviously isn't going to enter the kid order. And if it's a paternity case, you're not going to get the property order, but you are going to get the kiddo order. And basically, as you can see from looking at these orders, the way they work is this. These orders tell the parties all the things they cannot do without prior written consent of the other party or prior court order. And the orders are effective on the plaintiff as soon as the case is filed, and they're effective on the defendant as soon as the defendant is served. So if you file the case, your client's going to be under the joint TRO before the other side is, especially if they're going to dodge service and stuff for a while. The property joint TRO is basically designed to put a freeze on the status quo of the parties so that people can't hide assets, people can't. The example I give in the outline is sell the Corvette to your brother for $100 and then buy it back after the divorce. It's designed to prevent financial shenanigans. And you can see from looking at the exhibit, it's more complicated than that. But it prohibits basically incurring new debt except for 3 things: reasonable and necessary living expenses, operation of a business if you have to buy and sell inventory or pay payroll, and of course, because lawyers draft these, to pay your lawyer. You can always do that. Same thing for property. You can't get rid of community property. You can't get rid of the other side's separate property unless you have to pay necessary living expenses like rent, mortgage, food, insurance, things like that. You're not supposed to be able to go out and buy a new big screen or take a trip to Disneyland when you got a divorce pending and waste community assets. The purpose of the children TRO is to minimize the trauma to the kiddos. It prevents saying bad things about the other parent in front of the kids. It prevents taking the kids outside the state of Idaho for more than 72 hours. Things like that. Both of these orders in Ada County also prohibit things that are already crimes: harassment, assault, battery, et cetera, but they're reiterated in these orders that those are also big no-nos. You can read the orders for yourself. Because of time, I'm not going to go through them, but just know that the ones I've attached, like I said before, are the Ada County versions. Ada County's got probably the most comprehensive ones. Every little county has their own different version of them. Some counties just have a real basic one that doesn't do a whole lot. But basically, they've come around to the idea that when they have some kind of a domestic case involving property or kids, they're going to flash these orders right into effect right off the bat, just to kind of get people's attention. And you need to remind your clients about them, because typically your clients aren't going to read these things. They're kind of fine print. You're going to have to say, hey, read these orders, understand them, call me if you have questions, follow them. It's a big deal to the judges if you violate them, and you can prove it. Third general type of order is the Domestic Violence Protection Order. That's Exhibit 4. I've attached the whole statutory scheme so you can see how that works. Here's a quick summary. Most of the time, those are obtained by clients pro se before they even see a lawyer. They have people at the courthouse that will assist them in filling out the paperwork. To get a domestic violence protection order, you have to make an allegation under oath of either recent physical injury, sexual abuse, forced imprisonment, getting locked in the house or locked in a door or locked in a room, or the threat thereof. There are specific allegations you have to make. If you don't make them, you're not going to get one, no matter how badly you want a protection order. The other thing is the subject of the domestic violence protection order has to fall into the statutory category of either a current spouse, a former spouse, cohabitants that have a kid, a child, parents, children, or somebody in a dating relationship, or somebody related by blood, adoption, or marriage. So you can't get him against cousin Elmer if he doesn't live with you and you don't have a kid with him. Okay? So the two things to look at for these are, can you make the allegation that is required as to the type of conduct that's occurred or been threatened? Is it recent? You're not going to get one if you come in and say, a year ago, my husband slapped me in the face. The court's going to go, stale, get out of here. It's got to be recent. And you got to make sure you have the right category of respondent, because you can't just get a domestic violent protection order against anybody. These orders are usually issued ex parte. The court will then issue an order and require it to be served on the respondent party and set a hearing within 14 days. The way hearings work is, if the party that requested the order and got the ex parte order doesn't show up, it's dismissed, no questions asked. It's dismissed without prejudice, but it's gone. If the defendant doesn't show up or the respondent doesn't show up, the order is automatically extended, no questions asked. Okay? If either party shows up at the 14-day hearing and says, Judge, now I have an attorney, they have a statutory right to an automatic continuance under the statute. So you can always delay, the order is going to get extended, but you can delay the hearing on whether or not to keep the order in effect for a long period of time by either party showing up with an attorney. Now, the court can do a whole bunch with these orders. These orders can involve no contact orders between the parties and children of the parties. They can involve no communication. The court can set a custody or visitation schedule in these orders. The court can kick a party out of a house if you have a domestic violence situation, which is typical where both parties live in the same residence. The court can boot the bad guy or bad gal out of the house during the pendency of the order. Basically, the sheriffs go and say, they go and supervise the pickup of the clothing and the personal effects, and they're out of there. They can order treatment or counseling. And the part that Richie probably likes, being a constitutional guy, they have the broad, whatever other relief the court deems necessary, which, believe me, some judges interpret with a wide swath. Yep.
On the temporary possession of residence, does it matter who owns the house?
It's got to be community. I mean, the court can't dive. I haven't seen a case where the court has ordered a party to stay in the other party's separate residence. Typically, these are community residence scenarios 90% of the time. Okay? If you got little kids, I think the court could take the position that for a short period of time, I'm going to allow mom and the kiddos to live in dad's house if they've been living there for the last 5 years. Because the number one thing the court's looking at here is minimizing trauma to the kiddos. So I think most of the time you're going to see these are community residences or rental cases where you got joint tenants that both signed leases. These orders can't exceed 1 year. However, if you go back in a year, the court can extend them for another year. So the initial order, once you have your 14-day hearing, the longest it can be issued for is a year. However, the court can come back, either party can come back during the year and ask for it to be extended another year. Typically, you're going to, in a lot of these cases where there's domestic violence, you're also going to get a coinciding divorce case filed, a paternity case filed that's going to have a different case number, different judge, and at some point you're going to have to decide, do I consolidate it with the DV court? Do I consolidate it with the divorce court? Sometimes the parties will stipulate to modify or trim down the DV order, things like that in the divorce case, especially once they both get counsel. All right, final type of restraining order or no contact order are criminal no contact orders. These are generally filed and issued immediately against people charged with certain categories of crimes. Those include assault, battery, ag assault, ag battery, domestic assault, domestic battery, stalking, telephone harassment, things like that. When somebody gets arrested and charged with one of those, as a condition of bail, the judge, before they let that person out of jail, is also going to issue a no contact order. Okay? They are part of the criminal case, and violation of a criminal no contact order is a separate crime. The first violation is a misdemeanor, the second violation is a felony. It also, by the way, is a crime to violate the third category of order that we just talked about, the domestic violence protection order. These things are always subject, the category 4, the criminal no contact orders, are always subject to modification. They go away at the conclusion of the case unless the party is found guilty, the defendant is found guilty, and the court decides to continue the no contact order as a condition of probation. Okay? And oftentimes, you'll have the weird situation where in a criminal case, the plaintiff, of course, is the state of Idaho, the defendant is the criminal suspect, and then you've got the unrepresented party, which is the alleged victim, and they may come into court and ask the court to modify or quash the criminal no contact order. The courts take that with a grain of salt because of what they call the cycle of violence, where people that are victims of domestic violence are threatened, cajoled, promised, or otherwise coerced or talked into agreeing to get rid of these orders even when it's not in their best interest. So just because the victim of a domestic assault asks the court to quash an order or modify it doesn't necessarily mean the judge will, and the prosecutors often oppose that as a matter of law. All right, third item I'm going to talk about today is expungement. Expungement is a fancy word for erasure. It means to wipe out somebody's criminal record. People always want to have their records expunged. Law enforcement always doesn't want to have them expunged for obvious reasons. There's two basic methodologies to do this with in Idaho. Before I get into it, I didn't have time to finish this part of the outline. There's a whole bunch of different databases. When somebody comes in and says, I want to get my case expunged, you have to explain to them that they need to understand all the different databases that are out there. Here's the ones that are important. First of all, there's the State of Idaho Police, State Police Database. It's called BCI, Bureau of Criminal Identification. It's where the state police amalgamates the results of all the criminal cases from all 44 counties. There's the federal database, NCIC, the National Crime Information Center. That's kept by the FBI. That's an amalgamation of all the state databases plus all the databases from the district courts, from the United States district courts from all over the U.S. Okay? So if it's in BCI, it's also in NCIC. That's the critical point to understand. There's the Idaho Supreme Court Repository that you're all probably familiar with. That's a public database. We, as civilians, don't have access to BCI or NCIC unless we want to look at our own record only. But I can't look up John Glenhall's record on BCI or NCIC. I can go to the repository and see any civil or criminal case that's been filed against him, but I can't look up his BCI record or his NCIC record and see what's out there from other states or things like that. And as you know, the repository only goes back so far, I think 95 in most counties. The NCIC and the BCI records go back as far as they can go. You also have the clerk's record database where you can go in and look up on the computer, for example, in Ada County. Those are the four main ones that you can talk about expunging. There's a couple databases you can't expunge even if you want to. Those are the private prosecutors' databases, the Ada County Prosecuting Attorney's Office, the Boise City Attorney's Office, and then the law enforcement databases that the Boise Police Department has and the Ada County Sheriff's Department has. You're never going to expunge those, but they're not publicly accessible anyway. So an employer doing a background check's not going to hit them. Okay, expungement. In Exhibit 6, the only thing you have to look at is the last subparagraph 10. And what it says is, if you get arrested or served with a summons and they end up not prosecuting you within 1 year, or if you get charged with the crime and you get acquitted, you can expunge your criminal record. Now what that really means is you can expunge it from BCI only. Okay? And the word acquitted is not defined by statute. The state police take the position acquitted means you went to trial and the jury found you not guilty. I can tell you that that there are cases where the prosecutor will voluntarily dismiss a case, or at the preliminary hearing in the case of felonies, the judge will say, state, you don't even have probable cause. I'm not going to bind this person over. This is dismissed. I've been able to talk them into expunging cases under those scenarios, under the argument that's even better than acquittal, because acquittal means they had probable cause and went to trial and the jury said no proof beyond a reasonable doubt. But when the judge dismisses a felony at preliminary hearing, it means you ain't even got probable cause. You don't have squat. So there's a very nice lady at BCI. Her name is Wanda. She is the go-to person. She's not an attorney. She's not a deputy AG, but she knows this stuff inside and out, and you want to be her friend, trust me. So the first thing you do is follow this. If you have a client that's been charged with a crime but never brought to trial within a year, or you have a client charged with a crime who goes to trial and gets acquitted, or beats it at prelim, this is the way to go. You submit a sworn statement to the state and an order, and if it meets the statutory criteria, they're going to expunge it. Here's what you want to do in your cover letter. You want to ask them to send you a printout of the new expunged record showing no record, and you want to ask Wanda to send it to NCIC. NCIC will just throw away your private attorney letters. Don't even send them. But if you can get the state, BCI, to send a letter that says, we've expunged Richie's burglary charge from our database, now you can expunge it from yours, NCIC will do it. BCI and NCIC are the two big databases that private employer search things look at, because they make clients sign a consent, or applicants sign a consent to look at them. Now, that leaves you with the repository and the public court databases. In order to get at those, this statutory scheme does nothing to those other databases. So it doesn't do you a lot of good to expunge BCI and NCIC if anybody can get on the repository and still see it. Now, there's no automatic right to expunge from the repository or from the court databases. The way you can do it, if you qualify, is under the Idaho Administrative Court Rule 32I. And as you can see, there's 5 specific grounds. You have to allege or prove one of them. The ones that generally work the best are item 2, that the materials contain facts or statements the court may find libelous, like it's an untrue criminal charge, or they contain facts or statements that compromise financial security or could result in economic or financial loss. You have somebody that's up for a promotion and he or she can't get it because they got this dismissed marijuana charge on their record. Or ground 4, the documents or materials contain facts or statements that threaten or endanger the life or safety of individuals. You have somebody falsely accused of sexual abuse and the case gets dismissed. Then you have an argument, hey, I'm getting harassed, people aren't giving me jobs, et cetera, et cetera. That's the way to get the repository records sealed and to get the publicly accessible local court clerks databases sealed. And if you can get those 4 databases either expunged or sealed, then your clients are pretty well immune from anybody finding out about stuff. Like I say, you're never going to get to the police officer's private database or the sheriff's or the prosecutors, but that way you can get to most of them. So I don't know if I have time for questions, but
a couple if there are. There's maybe 2 questions.
I just wanted to meet with you in the hallway for a moment, if you could be gone for a moment.
sure, no problem.
The private, or the law enforcement databases, could those be accessed through a public record request?
Nope. Nope, they're for investigative purposes only. They won't cuff up any information to anybody but law enforcement. Okay?
Mark.
You bet. Good to see you, man.